Reading a patent specification. We had already seen the structure of the patent specification, that there is a title, abstract, description, claim. We had seen format, which is normally filed in the US Patent Office, and we had also seen an Indian patent specification. Now, having known the structure, it should be much more easier for us to read the patent specification, because the patent specification is a document that is created by a group of people, patent attorneys, in coordination with the inventor. So, over the years, there are some conventions that have developed as to what can come within a patent specification, and there are certain techniques or requirements which have to be satisfied while drafting these documents. So, let us look at how to read a patent specification, and let us also see what is the function that the patent specification performs. Now, before we look at the patent specification, we have to see that there are certain concepts in a specification. Though the specification is a document, we need to understand certain concepts in patent law which come in repeatedly in the patent specification, and unless we have a good grounding on these concepts, it may be very hard for us to understand what function is being done by the specification. Now, we divide these concepts as prior art, or requirements that a patent specification should address with regard to the prior art, and internal requirements. Internal requirements are requirements that the patent specification has to address within the document itself. So, you can call them external requirements and internal requirements. We are using the word prior art because prior art is the reference point when it comes to knowledge. So, there is some knowledge that is contained in the patent specification, and there is a comparison that is being done by the applicant to the prior art. You saw that field of invention, background of the invention. These are all instances where the applicant would bring in some amount of prior art or prior knowledge to say that there was a problem. In some cases, as we saw in the combination pen, there was a problem in the prior art and the invention solved that problem, which is what we call the problem and solution approach. So, the prior art, the patent specification has many concepts, and these concepts are established concepts in patent law which figure within a patent specification. Now, let us look at those concepts in detail. Now, on prior art, first thing that the patent specification should satisfy is novelty. The claim drafted in the claim part of the specification should be novel. Novel means that the invention should be new, what is claimed has to be new, and it should not be anticipated by the prior art. Anticipated means there is a disclosure, and the disclosure completely has all the elements, all the integral elements or the technical features that is covered in the claim. If the claim has 5 technical features and the prior art before the claim was filed, a disclosure in another document before the date of filing of the claim, if the prior art completely mapped all those 5 technical features, then we will say the invention is anticipated by the prior art. So, when the invention is anticipated by the prior art, we say there is lack of novelty or there is no novelty. So, novelty is something which has to be satisfied in the specification itself. So, if you draft a specification which overlaps on an existing prior art, though you may have done a good work in drafting the claims, if you have not done the check with the prior art, then there could be a possibility that the claim that you have drafted, all the essential technical features have already been disclosed in another prior art, and because it was disclosed in another prior art, your claim would lack novelty. So, novelty is something which has to be demonstrated in the claim part of the specification, and it has to be compared with the prior art. Inventive step. Just as novelty has to be satisfied by the claim should also satisfy inventive step. An inventive step is much more stringent yardstick than novelty, because in determining an inventive step, we look at the invention from the viewpoint of a person skilled in the art. it should not be obvious to a person skilled in the art. So again, you find that the specification will have to consider the prior art, and the claims have to be drafted in a way it is not obvious to a person skilled in the art. Utility. Utility is the fact that the invention is capable of industrial application. The other word for it is utility. Utility is not a comparison with the prior art, but for there to be utility, it has to be understood from the use to which the invention can be put to. If the prior art has a particular use, you are going to claim that one of the objective is to use this invention has a different objective which the prior art did not address. Or if the prior art had a problem, the use of the invention solved that problem. So again, there could be some comparison between the prior art in demonstrating utility. Utility is also called the third requirement, which is also known as capable of industrial application. Priority. Claims, when they are filed, for them to be valid, they should have a valid priority. Valid priority in the sense that there should not be any prior disclosure before the point on which the claim was drafted. So priority, every claim has a priority. We will see that in section 11, that each claim will have a priority, and the priority of a claim can either be referred back to an earlier document, or it can also be, priority can also be given up, and claims can be post dated, antedating and post dating. We will look at that in greater detail in the forthcoming lectures. So priority is, again, to determine priority, there has to be if there is a prior art, a prior disclosure before your date of priority, then that could be used as a prior art for invalidating the invention. So priority is a concept which is outside the specification, but nevertheless in drafting you will have to consider it. Subject matter. Whether the claimed invention is a subject matter that is excluded or not is going to be a comparison with something, it is going to be an external comparison. For instance, there are certain subject matters that are excluded from being granted a patent. A literary or an artistic work cannot be granted a patent. So that's a subject matter exception, and subject matter will determine what kind of protection you will get. There is also a requirement that biological materials have to be disclosed, and there is a requirement for depositing biological material. Now that has to figure in the complete specification, though it is something external. If the biological material is available in the public domain, you have to refer it in an identifiable manner, or if it is not available, then you will have to deposit before a depository. Now with regard to the internal requirements, there is a concept called enabling disclosure. So in the descriptive part, you are going to describe the invention with examples, with illustrations, drawings, and showing how the invention works. Now the standard of disclosure is that the disclosure should enable a person skilled in the art to come up with the invention, to make the invention. So there is a particular standard, so you cannot just have a skeletal disclosure or a bare disclosure without getting into the details, which if a person skilled in the art reads it, will not be able to come up with the invention. So the disclosure in a patent specification should be of such a standard that the person skilled in the art who reads the patent specification need not come back to the with any doubt. So it has to be a complete disclosure, and the disclosure should also enable the person to come up with the invention. So the descriptive part will have illustrations. If a person skilled in the art looks at those illustrations, he should be able to work the invention as it is described and come up with the invention as a product, as an end result. Best method. Section 10 requires the disclosure of best method. Best method of working the invention has to be disclosed. Again, it's an internal requirement. Enabling disclosure, it's an internal requirement. If the disclosure that is done in the specification is not enabling, that can be a ground for revocation. Similarly, if the best method is not disclosed, it could again be a ground for revoking the patent. Definiteness, again, it's a requirement under section 10. It requires the claim as it is claimed to be clear and succinct. So definiteness requires the claim to be clear and succinct. There cannot be ambiguity in the claim. If the claim is ambiguous, again it can be a ground for rejecting the claim. That's an internal requirement. Fair basis, again it's a requirement under section 10. The claims have to be fairly based on the matter disclosed. Now we had seen earlier that the patent specification broadly has two parts, the descriptive part and the claim. So whatever is claimed in the claims part should be based on something that is disclosed in the specification. What the Act says, section 10 says, on the matter disclosed in the specification. So the fair basis is a requirement that you cannot claim something which you have not disclosed. So you should disclose something in the descriptive part, and based on the disclosure you should make a claim. So if there is a claim which incorporates an element or a part which is not disclosed or explained in the descriptive part, then we say the claim is not fairly based on the description. So the claims have to come from the description. Now the claim, you can, one analogy or one example that will help you understand a claim is like a prayer that you make in a suit that you file before a court. If you file a complaint or a petition as a petitioner before the court, normally you will request for a prayer. You will ask the court for a relief. The relief will be in the form of a prayer. If you have a dispute between your neighbor, if the dispute pertains to land, say your neighbor has encroached on your land, so your prayer will be to injunct him, to stop him from encroaching and to claim back the land that he has encroached. These are going to be the reliefs that you claim. So the prayer or the relief that you claim are going to be based on what you have pleaded in your case, what you have pleaded in your petition or your complaint. You may not ask for a relief without giving the factual circumstances for claiming that relief. You cannot ask for your neighbor to be arrested because you have not pleaded a case as to what wrong he had done for which he should be arrested, because the civil consequences will be different from a criminal case. So you cannot ask for any relief that is unconnected to what you have pleaded in your petition or in your complaint. Similarly, you cannot claim something that is unconnected to what you have described in your descriptive part of the invention. So this is what we say fair basis. The claim should be fairly based on the matter disclosed in the description. So if a claim contains something which is not disclosed in the description, that could be a ground for invalidation. Section 10 also says that an invention should be contained in a single application. One application per invention. If there are more than one invention, then there has to be a similar number of applications. So there is a single inventive concept, or the fact that each application should only contain one invention. So if you have multiple inventions and you combine all these multiple inventions in one single application, then the patent office may require you to divide the application depending on the number of inventions you have included in a single application and pursue them as separate independent applications. So from this we understand that there are certain requirements that the specification has to satisfy, some of which are compared with the prior art or what we call external requirements, and others are what we call internal requirements. Now priority is a concept that is tied to the length of a patent. Length of the patent is the time during which the patent remains valid and enforceable. From the date of the application till the date the patent expires is what we call the length. Priority determines the length. The length of a patent is determined by the priority. So when you get the priority, you can determine the length of the patent, the time period during which it is valid can be ascertained. Now each claim has a different priority. We will see in section 11 that the priority for each claim will be different, and there can also be cases where there are multiple priorities. Claims can also have multiple priorities. The length of a patent is also determined by revocation, because normally a patent would be alive if the patentee pays the renewal fees over a period of time. It can be kept alive for 20 years from the date of application. But if there is a challenge to the patent and if the patent gets revoked, then the length of the patent gets shortened. The length of a patent may get shortened even if the renewal fees are not paid on time. Then we would say that the patent has lapsed. If there is opposition, then the patent term may, again the length may shorten, or if the patentee voluntarily surrenders the patent, or if it is revoked in proceedings. Now these are multiple instances where the length of the patent can be affected. Now let us look at the parts of a specification. The title performs the function of indicating the subject matter of the invention and disclose the specific features of the invention in not more than 15 words. So you can see the section and the relevant provisions. The abstract provides technical information, can be amended by the controller, is a concise summary, not more than 150 words. It indicates the technical field, the technical advancement to existing knowledge, principal use, and it is used as an efficient instrument for searching in a particular field. Description. Now the descriptive part of the patent, every specification shall describe the invention. Drawing shall be a part of the specification. Describe operation, use, method of performing. It shall disclose the best method known to the applicant, and if biological material is there, then the deposit under the Budapest Treaty within 3 months from the date of filing the application. These are the requirements that the descriptive part has to satisfy. The background, prior art, problem solved and contribution made, these are the different headings that you normally find in a description, which we had already seen in the US patent that we had shown you. Drawings, they shall accompany the specification, they shall be in separate A4 sheets, that is a requirement under Rule 15. The provisional specification can have drawings, the complete specification can refer to the drawings filed in the provisional. Dimensions not to be marked shall not be marked in the drawing. No descriptive matter except for flow diagrams, we had already mentioned this. Models and samples, the controller may insist on models and samples. Models and samples are not mandatory. Invention relating to perpetual motion, the manual says that if somebody claims an invention for perpetual motion, the patent office may insist on a working model. The models and samples shall not be part of a specification, whereas drawings are considered to be a part of the specification. So that's a difference between models and samples and drawings. Claims. The specifications shall end with the claims. As we said, the concluding part of the patent specification is the claim. They define the scope of the invention, the protection is claimed for what is in the claim, and that is what can be enforced. Normally the claims have to be the minimum number of claims that you can have without paying any extra fee is 10 claims. So any claim more than 10 will incur a extra fee, and the specification length, the descriptive length shall be 30 pages. Each claim in addition of 10 shall be charged. The claim by convention is drafted in one sentence. We have already seen an example of that.